what I'd like to do is talk about primarily claims with respect to separately owned real property and ultimately the burden of proof with respect to the claim for a share in the appreciation of separately owned real property, if that's the issue in the case. And in the chat is a copy of a decision that I received from Judge Amy Porto in Westchester on the case I was in court on again yesterday, where the husband came into the marriage in 2015 with a separately owned property at Heritage Hills in Somers, New York. And Catherine, just so you know, that was a property that was developed in the 1980s, primarily for people 55 and over. And it's actually a pretty huge property, you
Yeah,
know.
my mom lived there, actually. I
Yeah.
just wanted, before you begin, I want to make sure everyone got that order. Is that in the chat? Did I do that right or no?
I don't see it.
Okay, that's what, okay. All right, I'm gonna try it again. I see it on
Yeah,
my,
I am transcribing this call. Nope, I just see someone transcribing. I don't see anything else in the
okay,
chat.
okay. I think it's because I entered it, I did it before. So let me, okay, go ahead and I'll do it while we're talking, okay? And then we'll
Okay.
just do thumbs up. Hopefully it'll be there.
All right. And I guess as people come on, they can pick up from where we left off. But so with respect to separate property and real estate, um, it's an unusual area where over the course of the last 40 plus years, courts have been willing to recognize separate property claims where one party either owned the property prior to the marriage or where the parties purchased a property during the marriage in joint names, but a party came into the purchase and paid the down payment or part of the down payment with separate funds. And so I see roughly four categories that are applicable here with respect to real property. And those categories would be, well, first, where a party came into the marriage with separately owned real property and it always maintained its character as separate. And just, basic equitable distribution law from the statute is that separate property remains separate and is not subject to equitable distribution. It's got to be fall into a category, the category of marital property for it to be subject to division. And so under the definition of separate property and where it gets complicated, especially with separate property owned before the marriage, is this concept. I think it's subdivision D of the definition of separate property, where it talks about the non-titled spouse being entitled to a share of the appreciation in value, which resulted from the direct or indirect contribution of the non-titled spouse. And so in the case that I have right now, which I was in court on again yesterday, I made motions for summary judgment and then a subsequent motion in limine because the case was set down for trial. And this is the case with the decision that you see. And that's the decision on my motion for summary judgment. And so just to go through that as an example, my client purchased this condominium townhouse in Heritage Hills in Somers, New York in 2013. The parties were married in 2015. No children of the marriage, both parties in their 50s or 60s at the time of the marriage. And the property, so when you have this issue, you need to get appraisals as of the date of the marriage and as of the date, presumably, of commencement of the divorce action. And so we had our appraisals, And so the issue became the wife's claim that through her direct contributions by improving the property and contributing to the renovations to the property, and by so yeah, I mean, those were the concepts that she was relying on, that she was a contractor in a prior life, that she was contributing to the purchase of supplies from Home Depot, etc., and therefore she should receive a share in the appreciation and value of the property. The appreciation was probably in the ballpark of $100,000 to $125,000 from the date of the marriage to the date of commencement of the divorce action. And what ended up happening was she never obtained an expert appraisal. So this is that whole area of active versus passive appreciation. And our argument was that the property had appreciated based on market forces, and that nothing she did really contributed to the increase in value. And P.S., that as a result of her failing to obtain an expert report, there was no way that she could demonstrate the difference between appreciation as a result of market forces and the appreciation resulting from the work that they did on the property. And so initially, in the order that you see, the judge denied our application for summary judgment, but the judge did make certain findings, and the judge referenced, Sally Mae said she can't find.
It's in the chat. Do you see it in the chat, Sally? Let me see. Go back.
It's a
If you-
PDF.
It's a PDF. You should see it. If
Yeah,
you
I
go-
came in a few minutes late, so it's not in my chat. I'm sorry.
All
All
right,
right.
we can
Let me
figure that
see.
out.
Yeah, if you come
So-
in later, it doesn't show up. You only have
Okay,
to
I
check
just did
in
it
the-
again. Just did it again. See if you get it. Do you see it now?
All right, Melissa's good.
Yeah,
She
right?
couldn't have done this 5 years ago.
Yeah, I know. I'm a
Uh,
wizard. I should do a seminar on my wizardry. too,
That's right, that's
and have
right.
the space background too. Yeah.
So in terms of the motion for summary judgment, the judge denied our request for summary judgment, but the judge did cite extensively to the case Scher v. Scher, SCHER. And in that case, and I have the site if people want it, but in Scher, the court clearly laid out this active passive relationship. And the court said, the judge in our case, referencing Scher, but not specifically citing, said the matter will be resolved at trial wherein the defendant must establish that she made contributions and the increase in value of the home was attributable to those contributions. And you can see the reference to Scher on page 8 of the decision, just above the decision on counsel fees. And so based upon that, and based upon what we did in serving a demand for expert witness information, the other side never responded to that demand. So I made a motion in limine, which the judge decided yesterday. And the wife was pro se because her attorney withdrew, essentially because the wife was claiming that that the attorney wasn't representing her properly. And so because the wife was pro se yesterday, she advised the court that she was not going to submit any opposition papers to our motion. And the judge then granted our motion because there was no opposition, and granted the relief we were requesting. So that's an example of a situation where the property was owned separately prior to the marriage, and the parties never, or the title party never transferred the property into joint names. So we know we come across cases where something different happens where the person owns the property before the marriage and then they transfer it into joint names during the marriage. So it becomes a marital asset. And, the issue there really becomes the burden of the titled spouse or the originally titled spouse to demonstrate the value of the property at the time that they transferred it. So, and that is really more of an appraisal issue. So that's somewhat more straightforward. But I want to go back for a second just to this idea of burden of proof. And I know we're talking about litigation, and we can relate this to collaborative and mediation. But in litigation, the issue of the burden of proof is really critical. And that's what I was trying to hone in on in my case before Judge Porto. And, based on her decision and reference to the Schur case, the burden was on the non-titled spouse there, where the property is transferred into joint names during the marriage. The burden is really on the titled spouse to establish the value. And I haven't actually gone to find cases, but the cases that I've read previously often jump to the idea that after you determine the separate property value, which would then be credited to the titled spouse or the originally titled spouse, then in most instances, they divide the remaining equity 50-50 between the parties, although they don't have to. And, I'm happy if anyone has had cases like this, if they want to weigh in and give an example. But these cases come up. I'll keep going down because I do have other examples with some of the different scenarios.
Before you do that, Ken, I
Sure.
think Catherine shared something in the chat. Catherine, do you want to speak to, you had a similar situation was it a collaboration or mediation?
Yeah, I had it in two cases, one about a year ago and then one actually just now, it's active just now. One is a collaboration and one was kind of a negotiation around mediation. It was a mediation and then the consulting attorneys got involved and this issue was a big part of it. And I think hearing you, Ken, it's so helpful. There was no active the non-titled spouse. There was no activity on their part to increase the value. It was solely market forces. But both times I was I represented the person who had the separate property, who had the apartment in Manhattan before marriage or had the home in another country before marriage, but they wanted to bring the value of those two properties into the conversation. And they made two claims. One was the one you're talking about, and the other was just, well, marital funds were used to pay down the mortgage. And in both of those, we did not use the appreciation. We used the pay down of the mortgage as a credit. And they were in both scenarios. So I just was curious if that comes up in your world, how that's handled.
Yeah, and Sally May also mentioned that in the chat. It's an alternative.
Oh, I see.
And yeah, it's an alternative. But you can imagine that, and possibly in your case, part of the reason that you did that versus the appreciation is that if you get into the appreciation, it's a much bigger number, versus pay down of principal. I guess it depends.
Yeah, well, I think in the first one in the New York City apartment, certainly that would have been much bigger. But in the current one, there was no appreciation. So actually, it would have been worse.
Interesting.
Yeah, it was the same as it was when they bought it. Pretty
Yeah.
close to the same.
Yeah, Alan.
Yeah. So Ken, in your example, your first example there, did the parties live there? He bought it before the marriage. Was that the marital residence?
The parties did not live there, to my recollection, prior to the marriage. I believe that the wife moved in subsequent, and no children. It was actually a somewhat peculiar situation because my client became disabled, and this person was his caretaker, and they ended up getting married, and she ended up getting citizenship, etc.
Oh,
So
But
another interesting part of this whole concept is recoupment. You could use that issue with respect to the mortgage pay down, but from the date of the marriage until the commencement of the action, if marital funds are used, and marital funds could be the income of the titled spouse or the non-titled spouse, you could make a claim for recoupment. And I've done that in cases, and that sometimes can rival the amount of the appreciation. And some judges will look at that kind of as a double dip if you're looking for both a share of the recoupment and appreciation, because the recoupment includes not only the mortgage payments, but all the utilities and everything having to do with the expenses to maintain the house. And I've been successful in getting the recoupment claims recognized. So did you deal with that as well?
it's interesting, Alan. No. The other side tried to make sort of cumulative arguments, but they never really made them that clearly. And so, but in terms of the recoupment, don't you get into a Mahoney-Buntsman problem where the courts don't want to look back and
Yeah,
question the decisions of the parties?
yeah, can you talk a little bit further about a recoupment claim and how you make
Yeah.
that?
Yeah, so what you would do is it's very simple to make the claim because you can show either if the parties have joint accounts, then the funds coming out of the joint account for the a betterment or payments toward the mortgage, utilities, insurance, and real estate taxes are clearly marital funds. And even if they're separately held accounts, if the income is earned during the marriage, it's a marital account, and then you're entitled to a half credit for that as the non-titled spouse. And I've done that, and Mahoney-Buntsman has not come into that. As long as you have the records going back, a number of years to show that the contribution was made from marital funds.
Mhm.
And that's a separate argument from the increase in the value. And that the increase in the value has a lot of difficulties also because you've got to show direct contributions. Yes, there's a proof problem. In your case, it sounds like a winner because she never got the proof that she needs to show what the value was, date of marriage and date of commencement.
Mhm.
But
Alan,
I think you can use both.
Yeah,
It just becomes a difficult argument sometimes because the court will look at it as kind of a double dip.
yeah. Margarita, do you
yeah,
have?
question for Alan. Is it going to make a difference if that apartment was rented out during the marriage? On the recoupment claim, if the rental income paid for all of the expenses, does that make a difference or not?
I think it does, as long as you keep that rental income separate. If you commingle that rental income with marital funds,
Okay.
then the answer is no.
Yeah.
If marital fund, if it's not a rental property, it's pretty clear that joint or marital funds are being used for its maintenance and upkeep. And that makes it
So-
an easier recoupment claim.
Yeah, Margarita, I had the rental situation before Judge Thorson in Westchester. And in that case, the husband owned one rental property in New Jersey and another rental property in California. And one of them, I think he owned with his sister, the California property. And Alan's point is right on in terms of keeping the money separate. In both of those situations, the rentals were like a self-contained universe, so that if you think about the definition of separate property, it was clearly separate and they were walled off effectively so that there was no direct or indirect contribution. So, Judge Thorson, when asked to weigh in on settlement discussions in that case, was pretty clear that he viewed those properties as completely separate. And I was pushing, and we actually the parties got appraisals of those properties. I was pushing it obviously for strategic reasons, but when we got to the issue of settlement negotiations, the judge did weigh in and viewed that as a different situation.
All right. Carmen, you had your hand raised. Is that still?
Well, I was just kind of I'm a little concerned about how we're throwing around kind of, the mortgage pay down when it's really just mortgage principal. And so, why is that? Why is it only the mortgage principal? And one argument is that because the parties, if they were on their own, they would have to pay rent. And so that's what the interest payment would be allocated for. But is there another reason? Like, is there actually a statute? Is there I mean, I don't know. Sally, you're like the tax guru. Is there like some sort of codification for why?
Well, it's more an interpretation of the equitable distribution law and the definitions of marital and separate property. And the concept of using marital funds to pay down the mortgage is the premise for coming up with the principal pay down as a possible way to get the non-titled spouse a share of some money. So in other words, if they take marital property, their income, and that's being used to pay the mortgage, then that's the connection as marital property, and therefore.
Well, no, I get that. I get that, Ken. It's just why only, I mean, clearly the principal pay down, depending on where they are in their marriage, is going to be significantly less.
I think Catherine, you had your hand raised, and then Mark, and then maybe Sally.
Yes,
Mike.
Sally wrote it impacts the equity, and that's really in our case, it was basically that the separately titled spouse was going to realize the value of that pay down when they sell it, and they keep all the funds because it would not be shared with the non-titled spouse. So that's the benefit that the non-titled spouse would have contributed toward the titled spouse's equity pay down. That's why they give you the credit. Is that clear? Am I saying it right, Carmen?
Yeah, I think, well,
No, I guess I'm not being clear with my question. Sally,
So do you want to say maybe Sally could? weigh
Well,
in?
Well,
what
I think Carmen-
what I wanted to say, I think Carmen's got a point, because going back to Alan's point that for the discernment they use utilities, because the interest is like an expense. It's not doing anything related to the equity. So we all agree that the mortgage principal pay down is impacting the equity, and that, that works. But the expenses and interest would be an expense. And so you could lump that with, and that's what I would want to have Alan speak to. Could the expense, could the interest be lumped with the utilities, the homeowner's insurance, and the tax? I mean, could it be lumped there, Alan, for a recoupment appeal?
Yeah, I mean that's possible, and I think a court is going to look at it because it is equitable distribution. They're going to try to work some kind of equity out because yes, even though the marital assets are being used to better either maintain or improve, because improvements are a big part of this also, and I've had those matters. The court might look at it, well, you would have had to pay rent, so that could be a set off against the recoupment claim. So it could get very complicated because again, when I talked about double dipping, you're getting recoupment, and then you're also asking for the equity. So there's two things that you're asking for, and it might be too far for a court to go on both of those. And I had precisely that issue. We ended up settling the case, and I got all of my recoupment claim, but none of the equity.
Yeah. Well, I think that actually computing all of it and keeping it separate, that's like a good start to see if you should go that route, because then in some cases, and it can be kind of a complex calculation actually. So, but you should maybe go through that. That helps the couple decide, I think, whether or not to even pursue it, because you then look at what's it going to cost you to pursue this if you're not going to be able to settle it. But also too, it helps them see what the dollar amounts are so that you can they can decide, maybe we should just like do this a little bit differently. I mean, so all that information, bringing it to the table, I think is very useful in these different cases.
And Alan, in the recoupment, is that only in the situation where one party owns the property separately, that it's never been transferred?
Yes.
Okay.
Mark, did you want to share something? Oh, wait, you're on mute anyway, but I mean, you could unmute yourself.
But we'd like to hear from you
Yeah, I
because you're
know.
one of the founders of the organization.
Oh, boy. Yeah, so I'm
Wisdom.
omniscient on everything, and my answer is that everybody else covered what I was going to say. I mean, I have nothing additional to say. Thank
All
you.
right.
All right, well, it's good to hear from
Thank you for being here.
Thank you for having me.
So I do have a case right now, which was a mediated case and is on the cusp of litigation, but where there are two properties, and one property is in New York City and one property is in a neighboring state. And the New York City apartment was purchased within about a year after the parties got married, but with significant separate property contributions from my client. And the Connecticut, I guess that's the neighboring state, the Connecticut property, again, significant separate property contributions from my client through inheritance and gift. On the New York property, it was easier to demonstrate a connection between the separate property and the down payment for the purchase of the New York City apartment. On the Connecticut property, it's more of a challenge. And, you know, that goes to the issue of burden of proof again. And, you know, Sally and Nancy, maybe you've done some of this work trying to connect money coming in from one party to the actual acquisition of the property. In my case, this is really the issue, and the burden here is really on the party seeking to establish the separate property claim, because both properties are titled in joint names. So that's been the challenge in the case, and the case has gone on for some time as a result of not being able to come to a conclusion on how to treat the separate property connection. Has anyone had a similar case trying to demonstrate that connection between money coming in as an inheritance and or gift from parents?
Yeah. And how it's treated in the collaborative process. I'd be curious to hear from David, Nancy, Sally, you know, as neutrals, how they approach it in their work, in their role in the process. Whoever wants to speak. No, Nancy, no?
Well,
David?
I had a mediated case. It wasn't collaborative, where it was really complex because the money came from both gifts and inheritance, but also it came from the sale of a prior property that the husband had owned before the marriage, and it was sold. And so we had to figure out how much of those sales proceeds actually were his, plus the, you know, going into the second one. So it was a very complex thing. And the only thing, and I don't even know how it's settled, it's come out, but because it hasn't gone to court, but it was just to lay it out, like where everything came. And I had this sort of complex spreadsheet that showed that, how I came up with the calculation. And it was interesting because, and this is a New York property in Brooklyn, and the mother of the husband is an attorney herself. And so she actually got involved in looking at the calculations and asking questions about them. And so we've come up with the number As to whether the wife is accepting it, I mean, I don't know where all that is, but I started out as a neutral with them, but then the wife didn't want any of my services, and so it ended up, so I wasn't a neutral in that case. I ended up doing it just for the husband, but you know, we had to do all the things like the value of each of the properties at the time. I mean, it was just real complex, and I actually
Right.
had another CDFA from California help me with the spreadsheet and stuff, because the Association of Divorce Financial Planners has we have support groups where we help each other with cases, so I have access to various people that have had experience in different things.
Right.
I couldn't have done it by myself, actually, but I now have a spreadsheet where, you know, but that's the only thing I know to do, is just to do the calculations, lay it out for people, and then see where they want to go with it.
Right. Right.
So I had a case, but it was, I mean, I've had several of these, but this one was fairly easy because when you looked at the closing statement, it was a check from the father. That was, you know, a photocopy of it so that you knew it was definitely separate property. So that was an easy thing. I think you always need documentation. I think the question also becomes, does it get, you know, the lawyers know the word, transmuted, that goes from one property to another property, and how that gets handled, and whether you agree upon whether you're going to add any growth to that, or it's just going to be the flat amount. So that's up to the parties and basically the attorneys how they want to handle it.
Yeah, it's interesting because I just wonder, when we had just a few people on, we were talking about when the equitable distribution law was enacted in 1980, and whether the drafters had any idea of the havoc that they were creating, but that it was certainly a better system than where people who were savvy enough to put title to property in their name left the marriage with the title to the property. You know, that was pre-1980, pre-equitable distribution law. And I remember over the years in the 1980s, I started practicing. Alan started practicing before me.
Don't give away
And-
our ages, please.
And we grew up with the equitable distribution law. And I remember Coffey, Coffey, being decided, I think, in 1987. And that was where his parents gifted money toward the purchase of a home. And I think that's certainly the earliest case I remember, where the courts recognize this concept of separate property contribution. And, you know, it's only because it's real property. And we didn't know over the years, you know, when we were handling cases, we didn't know if this was just a trend that was going to peter out and the courts would treat everything as marital and not allow separate property claims. And, you know, it really has become ensconced over time. And where courts are consistently doing this, and it's not a trend and they're not deviating, but, you know, they can do other things. Nancy brought up the issue of convenience. And, you know, you have those situations where the gift comes in, the gift is to both parties, the gift is to one party, but they put it into a joint account, and then it sits there for 2 or 3 weeks until the closing takes place. And, you know, how long is too long for the convenience argument? And so, and, you know, we all see that in the collaborative and mediation cases where, you know, if the money sits there for a year, you know, everyone knew that was the intent, but it sat there for a year. Is that, you know, I think the cases generally say that's too long. It's not convenience anymore.
Yeah. Ken, I had a very complicated case. It was not a collaborative or mediation, but there was a lot of movement of money, and the guy literally had accounts that had no check writing privileges. So he moved the money into joint accounts literally for like a day or two, and then wrote a check from there. And we were saying that was a matter of convenience, and the other side says, well, no, that's commingling, or, you know, it basically, you know, tainted it because it went from his personal in his name to a marital account. But because there were no joint, you know, there were no check writing privileges, it was kind of, to me, that argument was kind of silly. There were a couple of times though when we noticed that he made deposits into the joint checking account after the money came in and before it went out. And in those cases, that's a lot more complicated.
Yeah, most definitely. And as you said it, you reminded me of a case that I worked on in 2022 to 2024. And it involved, again, a New York City apartment going back. Our client purchased the property in the 1980s, and the parties were married in 2007. They lived in the apartment for a year or two or three. They sold the apartment, and then, of course, they didn't buy their house. They stayed in the apartment for like 3 months because there was that gap between the contracts for the purchase of the new house in Westchester, or the old house in Westchester. And because the client had records from 2010 with the sale of the apartment in the city, we ended up getting an appraisal of the apartment as of 2007 when they got married to show the value. And then the sale in 2010 to support our separate property claim. I mean, ultimately, we ended up negotiating the issue, but it's also amazing how some people keep records going back that far, and, you know, where the detriment of not having those records, because if he didn't have the closing statements and the copies of checks that he had from the closing, we would not have been able to substantiate that claim. Alan?
Then you just hit the nail on the head of the case that I had yesterday and settled in 3 different settlement conferences with Judge Heyer. And I think all of this teaches us as practitioners, as mediation, as mediators, as collaborative counsel. First thing you do with the client is say, what records do you have and how can you get those records? Because when you make a separate property claim, whether you're making it in mediation, collaborative, or in court, the proof is going to be required. In court, it's a very high burden. In fact, you got to show clear and convincing evidence when the possibility of transmutation occurs when you put funds that are separate into a joint account. And that point, David raised that point exactly. So in this case that I had, it had every one of these issues because the marital residence was purchased by proceeds from the sale of a separate property, and the funds that came from the separate property for a period of time went into an account, a joint account, because there were no other accounts. And it was a matter of months because there had to be they couldn't close on the separate property until after they bought the marital residence. So they had to get a bridge loan, and the separate funds were in part used to pay the bridge loan. And then years later, separate funds were used to do improvements. So I had every single issue that we had to deal with, and doing this in tranches before Judge Heyer was rather interesting. And he's been very helpful. I was thinking maybe at one of our points, we try to get him to talk to us like we've gotten Judge Grossman before and some other judges. He is very good at settling cases. Ken and I know this. I don't know if anyone else here knows how good he is at settling cases. And his approach it's a good approach. And I think that approach could help us in our mediation and collaborative practices as well. But yesterday was support, and he actually got us to the finish line on that. So the case is now over, thankfully.
Yeah.
What were the issues with the support? Not to divert it, that's interesting.
The issues with that's the great issues on support. You know, we're not talking about support now, but there was an argument made of imputation of income based on gifts given by the mother to the parties over a period of 3 years.
Mm.
And there's very specific case law on both sides. And we were both reading from our cases to the judge, and we were giving him a headache with the cases, but he tries to figure out what's the delta. Where do you disagree? If you have got to come to a certain point to meet what the claim is, and we ended up kind of right in the middle
Mm.
and settling the claim. But that imputation that's a great topic also.
Right.
Oh, and maybe next month.
Well, and I was before Judge Heyer. I seem to be before him too often, but
Oh, why is that?
that was my temporary custody trial over Rosh Hashanah. And he can get pretty intense, and he uses the idea of the counsel fees, and he presses parties to say, look, you can spend $100,000 on this hearing or trial, or we can work to get it settled. And he's very interesting. He's very hands-on. And I did have a support matter before him. And it was interesting because he, we always try and push the judges to say, you're going to go above the cap. And his position was, if it's a 50-50 case, 50-50 access, that he would use the cap.
Mm.
But that if it's not 50-50, that in my particular case, where the combined incomes of the parties were about $280,000, that he would do it on the total income of the parties. And same as Alan, in that case, he pushed the people in between the cap and the total income of the parties to settle support. But if I could just go back, I wanted to touch on one other area, and I've only had a few of these cases. Maybe Mark has had them as well and could talk about it. I've had cases where the parties purchased the marital residence before the marriage, and they used separate property. Obviously, at that point, everything's separate. And they took their property. In one of my cases, the husband contributed about $900,000. My client contributed about $250,000 to the purchase of the condominium in New York City. And on our end, we were arguing that it was effectively a gift by the parties to each other because it was done prior to the marriage. And the property was purchased in 2008, roughly a few months before they got married. And then they were married for roughly 15 years. And this was a case before Judge Waterman Marshall, who, like Judge Heyer, actually gets down from the bench and sits down at a table with the parties and counsel and brainstorms. And she, listening to the arguments on this, she took the position that it was equitable to recognize the separate property contributions, even though they were prior to the marriage. And that's how we ended up settling the case. But I'd be curious if other people have had that situation where they purchased the property prior to the marriage in joint names and then end up in court or in mediation or in collaborative.
How was the title held there, Kim? Was it joint tenants' rights of survivorship or tenants of common?
Joint tenants with rights of survivorship.
I can't
So-
think of a case, Ken, but just for my 2 cents is I think that's the right result. I don't see the equitable difference between premarital contributions and postmarital contributions. It just seems like, yeah, I mean, I think that's straightforward.
Right. Well, I mean, it's interesting because, Mark, that you know, when you think about it, was it a gift? Did each party effectively gift? I
It's a
mean,
creative argument.
yeah, I had it used against me.
Yeah.
That's where I adopted it. That's where I get a lot of my arguments.
Sally, did you want to share?
Yes, I just wanted to ask about the gift thing. So are you saying that this judge, you said it was gifts? Because my mind goes to, did they need to file gift tax returns? Did they file? Because this was going back before the large exclusion. I don't know how many years. I mean, I can't remember but it could. So I was just wondering if anything came up about that, about the gift impact.
That's a great question, Sally. So the purchase would have been 2007, 2008 timeframe. And no, there was no discussion of gift tax returns or the like. But would it be different because these people, I mean, I think they probably married in the year after the purchase. So they purchased in 2007 roughly, and they got married in 2008. So I guess they weren't spouses for purposes of gift and estate tax at the time. But, you know, I guess the husband could have also made the argument that he should get a greater share of the appreciation in value because he contributed a greater share to the purchase. And that may have been one of the arguments made, but
That's not the law for postmarital, so why would it be for premarital? But you don't, I mean, sometimes we write that in prenups or whatever, but we don't normally do a proportional return, right?
Right. So Mark, what's the most interesting equitable distribution separate property claim you remember from your
Nancy has her
many
hand
years
up.
of doing this?
Yeah, exactly. I was gonna
While he's
it's
thinking,
Nancy's turn.
while he's thinking, Nancy, did you want to share something before Mark?
Yeah, so I just have a
Mark has
question
nothing to
because
say.
it arose in another case, and I forget how it was ended up. Oh, Jamie was on that. So if the couple's gay, right, and they couldn't get married till years later, how is then that separate property or gift determined? If they've been living together for many years, almost as husband and wife, but without the license, how would that have changed the decision? Or would it have impacted the decision?
Jamie, do you want to talk to that, or did you do research to see what the case law was?
I don't think I did actually, but I think the argument that makes the most sense to me is what Mark was saying of, you know, the separate property shouldn't necessarily, if you're both contributed separate property, it shouldn't really make much of a difference whether it's premarital or postmarital, especially if it's in joint name, you live there together, the expectation, I don't remember if that's exactly what happened here. I think maybe, I don't remember, but the idea is it's effectively the same thing. And that was, I mean, it was a big part of the case was that they had been together, effectively married for all this time. And as soon as they were able to become legally married, they were legally married. So the question really is all that time before, you know, our client was the less money spouse. Our client's not getting as much, you know, equity as the marital property equitable division as he would have if they had been married if they were able. So, you know, that should also kind of come into the picture too.
How did it end up resolving?
Chaos.
Oh, really?
Chaos.
What does the chaos look like? What did it?
What? The more money
There was a lot of chaos, but one thing was that they lived their life with the moneyed spouse contributing 2/3 of everything, the non-moneyed spouse contributing 1/3, and they wanted the equitable distribution that way.
And our client was like, you know, that's absurd. And our client had felt like he didn't contribute as much to retirement because he thought that they'd be together forever. So he should get 50% of the more moneyed spouse's retirement, things like that. So it just,
you reached a settlement though.
yeah, after a lot of
Right. So you had Right. So you were creative, and that's the whole kind of approach. When we are in collaborative, we can figure out creative solutions, because going through a court process, there's a lot of uncertainty and a cost. And so it really is to everyone's benefit to reach something that could be just fair and equitable and creative approaches.
But it's also as if it were the non-moneyed spouse sometimes is the one that just generally, I shouldn't say generally, but caves because
Yeah.
of the expense of the process. And they're just had enough, and that is no matter, how they're married.
Well,
Yeah.
And I know it's a good issue, in prenups now, that's like a really good issue to kind of focus on, is separate property and defining it and having that. And if you do it collaboratively, which I've done a few, it really is a really good, discussion point and issues to address in a prenup, for sure. And that would inform all these cases that we're looking at, that informs issues that we address in prenups, which I think is really impactful and
I
helpful.
think also is how are fees paid? If that's addressed up front, kind of have a better feel of like, how long is this process going to be going on?
Yeah, I know we haven't talked about the separate property as it relates to retirement, but I know that's become issues in cases that I've dealt with. And I'm just curious as to when you look at the separate property appreciation of retirement assets and calculating it, that's pretty mind blowing what some numbers could be, from $20,000 could turn into so significant. And, but I think laying everything out and getting, if you don't have all of each statement from each quarter, some people, I had one client who did save it, but most people don't. And that becomes so challenging because you don't have records for things like retirement. I know that's a little bit, it is part of this. This is more about real estate, but Alan, did you want to share?
That was also part of the case that I just settled, was the retirement asset with the separate property claim, and the client was able to go back 20 years and get almost every statement,
Wow.
which was insane. But we would have had to hire an expert to look at the separate property, look at the increase in value, because if you try to use the S&P, it would come out to a number that was even more. There were also other contributions made during the marriage that would have made the calculation for you financial experts absolutely insane. But Bob Jones, who I spoke to on it, said, yeah, he could sit down with the statements for the 20-year period and look at what the increase in the value was for that separate property component, and not have to get involved in the other contributions and the increase in value to the marital contributions. But yeah, this can be very difficult. And going back 20, I've never seen someone come up with 20 years worth of statements. That was the first in my career.
Also, it gets a little complicated, even if you have all those statements, if they start shifting where the asset contributions are from one fund to another,
Right.
and then that just.
That was part of mine as well.
Oh my goodness.
But we had all the accounts.
Yeah, well, I mean, the good thing about the retirement funds is they're only in one person's name. They can't be in joint names, so you avoid some of the issues, especially with what we've been discussing this morning. But definitely the appreciation and value of the separate property share, and identifying the date of marriage values and all of those things. And so Melissa, other questions or?
Yeah, just with the financial neutrals, do you do that analysis or do you, bring in another person, or how do you approach it as the neutral? Because that could really taint your neutrality sometimes, or make a perception that, when you deliver some values, the other non-title spouse might be looking at you a little differently. So I'm just wondering how you kind of approach that.
Yeah. I mean, I have a spreadsheet that I use, and when I'm the neutral, I mean, I just show it and explain it, that this is what the numbers say. I mean, I feel like that's all I can do, and just be as objective and as attention to both of their concerns as possible about it, and just say, I am giving you information, putting it on the table for you to then for you all decide how you know, what do you want to go forward? Do you want more? You know, and just kind of make it so that this is a thing that the three of us are working on together to help you all come up with the best decision for your family. So I try to couch it like that, but I do show the numbers of how I got them. And if there's any concern about it, then I make changes, but I have a spreadsheet so I can easily, you know, feed that into it. I mean, you
Yeah,
have to have the spreadsheet. You know?
Yeah, if you have the numbers and you have the statements, you can easily do the valuations because it's not dollar cost averaging where they're putting money in on a monthly basis. It's like the starting value, and then you can kind of come up with the numbers. I just find it sometimes interesting when that moneyed spouse that has that separate property says, well, the S&P averaged X over the number of years, and this is the value. You can't really go by that because let's say in 2007, 2008, it took many, many years to recoup
Well, that's
all the
right.
gains that you had prior. So, you know, it always goes back to either showing the numbers, using just the value that you put in the statement prior to it, but it's really what the parties agree to.
Yeah, I mean, if we have the statements, it's really simple. We just plug it into the Excel schedule. It's when you don't have statements going back, it, you know, makes it more difficult to use the S&P. You know, do you look at what their performance was? What we like to do is look at what the performance was in relation to what the S&P was, you know, over a course of a number of years that we have the statements. And then you can kind of blend that into it, just explain it to them. This is what we're doing. Listen, it's not 100% because we don't have the statements, but you know, based on what was going on, this is what we can ascertain.
Quick question. I know we're almost out of time, but for the financial people, so if you do have, say, a lot of the statements over a 30-year period, and you have to do this analysis, starting value and what the growth was, what would in general be the cost of that to kind of plugging the numbers into the spreadsheets and figuring out the values?
Over 30 years?
Yeah.
Oh, you gotta kind of, it's not overly costly, but you know, we gotta double check our work and have, you know, it's a couple of grand easy.
Okay. Yeah, no, because I got a quote for $4,000 and I was just wondering if that was reasonable or not.
I don't think it's overly, you know, crazy, but you know, I mean, there might be people that can do it cheaper.
Yeah.
It just depends.
Yeah, I agree with David that, but I do think that sometimes people will give a little bit higher number and just, yeah.
Right. Sometimes, you know, we don't know what we're into, right? Because all of a sudden there's an account transfer and then we have to get those statements and then you have to start explaining why it's going to cost more. So, you know, sometimes it's good to take a higher retainer up front.
100% understood. Okay.
Right. And you don't know how long it's going to take to collect the data, what you're going to have to go through to get it from them. Sometimes that can, I mean, I've had to actually maybe charge extra for data collection, you know, process. So, you know,
well, listen,
depending on how the couples are or how the couple is.
Well, thank you, everyone. Thank you, Ken, for putting this together with me, like literally last Friday. So
great job, guys.
And but you know, but Alan, you're not off the hook. Yeah, I need a topic for next month, and the imputation of income is a really interesting one. Would people come to a pod meeting that talks about that and how the interplay with support? And
yeah, let's just look at the date.
Yeah,
it's the third Wednesday of the month at 9 o'clock. So whatever day that is in November is
12.
It's November 19th.
My birthday would be a perfect day to do.
Oh my God.
Yeah. And also too, going along with the income, if there's like any interest in knowing how you get income off of pay stub or tax returns or, you know, so I do it both for individuals as well as for businesses.
That's December. I love it. We have it down.
But Alan, in all seriousness, I think one of the complexities I come up with all the time are people, younger people just taking money out of their trust funds and Thank you, Melissa. You know, and then how do you trace that back? And then does it get commingled? I mean, it's just that whole nightmare of trust funds or of you know, again, with this whole trust fund, how the passive and the active involvement of the parties, you know, one party, the many spouse with the trust fund. And then all of a sudden, if it's active participation with that trust fund, it gets brought. I mean, the argument is to bring it back because of the active participation where there is no prenup. So, I mean, that still haunts me, that case.
All right, so hopefully everyone.
Thank you, Carmen.
A little bit today. Thank you, Carmen. Thank you, everyone, for joining. And I will see you
Thanks,
next
guys.
month or before then.
Thank
All
you guys
right.
so much.
Yep.
All
Thank
right.
you.
Sure.
And this
Bye.
is-
Take care,
this is
everyone.
Recorded, so you can see it again if you want to.
See some
Thank
of
you,
you
everyone.
later.
All right.
Bye.
All right, bye-bye. Thanks,
Take care.
Ken.
All right. Take
Okay,
care,
thanks,
Melissa.
Ken, you did a great job. Nice
Oh,
to see
thank you.
Mark.